piece. So perhaps you could just comment on that. What specifically about Bill C-75 would you change, or is it really how it's being implemented in the system that you don't like?
Thank you. And Chair, through you, there was quite a few points in there. I'll try and get them all for you. But to start with the Bill C-75, I think the application of the particular legislation right now is difficult. So we know that it's a ladder principle with regard to release from custody, and that the least onerous form of custody is to hold that person accountable for their behavior while they're waiting a trial is what we are letting people out on. Often that is the perhaps underserving victims in our community, because the least onerous, depending on the nature of that offense, is insufficient to protect our community once they've been released.
But just to reiterate, just to underline what you said, it's the application of the law. It's not the law itself.
Sorry. So it is the law itself as well, because it is how it's currently being applied, but it is also the law, because what it doesn't allow us to do is to jump to the top rung, which may be the most appropriate for the crime that has happened. And that is what we used to do. What we've done now is introduced essentially, we flipped it on its head, and we are now letting people out of custody who we wouldn't have let out of custody prior to that. Is there an overcorrection? Probably there has been an overcorrection as a result, and that's why I said I'd like to see that particular piece of legislation modified. And I believe that you have the Ontario Association of Chiefs of Police, the Canadian Association of Chiefs of Police, and many of the police associations who've all signed on to that. It's not to say that people shouldn't be let out. It's just to say that that particular piece of legislation needs to be amended in order to allow for a better application. So that was on that. I think we agree on the data sharing. There is insufficient data sharing with regard to intimate partner violence across jurisdictions, and even across our own, within our own provinces and across borders. If somebody has not been charged, then the likelihood of them appearing in a database that's accessible to somebody, another police agency, is next to nil. So we can have people who move from jurisdiction to jurisdiction. And as we've heard, within rural jurisdictions, there's a particular risk to people who are there and a lack of resources. Thank you. I see that 1 minute. And then what was another? You had another
standard qualification for justice. It's standard qualification for JPs.
I absolutely agree. There should be some standard qualifications for justices of the peace. We often find police officers are trying to provide just the most basic of education to when we're dealing with justices. And, to speak earlier with regard to hate crime, for example, there is a criminal code definition. We do have a definition for hate crime. And if we have to explain that to a justice, then we're losing the momentum, and oftentimes we don't even have that opportunity to do so. So there's a lot of nuances here at play, and
I appreciate that, Chief. Thank you very much for your insights. I'm wondering if Julie or Lenore want to weigh in on the bail system or anything else, or if you're good. I know the Chief is the expert, so if you don't want to weigh in, that's totally fine.
I think at this point, I'm out of time. It's fair to say that you are out of time, and it does conclude our panel. But